piracy was the dominant issue that consumed his life. As he once put it, if you cannot protect what you own, you don't own anything. And that's why, as co-stewards of copyright protection, we've worked together over the past 5 years to eradicate rampant online piracy once and for all, so creators and distributors are fairly compensated for their work. It's also why we'd like to applaud the Japanese government for link site legislation that went into effect on October 1st of this year. This seminar today, which brings together many of the best minds committed to improving the digital ecosystem for their creative colleagues, has enabled us to address the adoption of site blocking in the most thorough and reasoned fashion. In the past years, we've presented with quality research papers that have outlined the depth of serious levels of piracy in the market. We've heard from international experts in their fields who have shared their data on the efficacy of site blocking measures around the world, and we listened intently to independent distributors of manga and anime as they shared case studies on how their business improved when site blocking measures were established in their country. We benefited greatly from their perspectives, their insights, and their passion. And today we write another important chapter in what we hope will bring us closer to a more secure and protected digital ecosystem. So we look forward to hearing compelling evidence that site blocking is consistent with the Japanese Constitution, a necessary step towards achieving this measure being adopted by the Japanese government. But before handing things over to our distinguished guests, I'd like to express my deep appreciation to the following people for their longtime partnership and friendship in hosting this event, as well as our special guests for today's discussion. They include Hiroyasu Ando, chairman of the Tokyo International Film Festival, and for the broad support we received from the Japanese government, including Akira Amari, member of the House of Representatives and chairperson Research Commission on the Tax System from the Liberal Democratic Party, Shigeaki Tanaka, Secretary General, the Secretariat of Intellectual Property Strategy Headquarters in the Cabinet Office, and Shitaro Ito, member of the House of Representatives and Secretary General of the League of Diet Members for the Promotion of Culture and Arts. Also for our co-organizers and partners, Uni Japan, including Steve Lang, Minister Counselor for Economic and Scientific Affairs at U.S. Embassy Tokyo, and our special international guest who will join us from Germany, Jan Nordeman, attorney at law, certified copyright and media lawyer, and a certified industrial property rights lawyer, as well as Nobuharu Obinata, professor, faculty of law at Kumamoto University, and of course, our good friend Tomohiro Tohyama, attorney at law at TMI Associates. So I want to thank these friends and partners for contributing to what promises to be an illuminating discussion on a topic that matters to us all. Thank you for joining today. Please enjoy the discussion and have a great seminar. Thanks.
Thank you very much. Next, from the co-organizer, I'd like to have Mr. Hiroyasu Ando, the chairman of Tokyo International Film Festival, to give us a few remarks. Mr. Ando, please welcome him with big hands. Chairman Rifkin, thank you very much for that message. And Chairman Amari, as well as ladies and gentlemen, good afternoon. The entire world is still suffering greatly from the COVID-19, but when it comes to the Japanese film industry, we are gradually making steps forward towards normalization. We were able to have a great hit movie title called The Demon Slayer. And I am also very happy that we have been able to physically hold the Tokyo International Film Festival by taking full measures against COVID-19. And we are commented and received words of welcome within Japan and outside of Japan. Good thing that we were able to hold it physically. So this year, the goals for a TIFF are as follows: to once again acknowledge the joy of watching films at the film theaters and to strengthen the international solidarity through the films, and furthermore to deepen our observations through the discussion on the post-COVID film culture. Therefore, in that regard, this IPA seminar is indeed very much suitable for this year's film festival, mainly focusing on the theme of contents protection. You'll be having a discussion for the future of the film industry. So I look forward to having a further fruitful discussion. Thank you very much. Thank you very much, Mr. Ando. Next, I would like to hear some words from the honorable guests who are with us today. First of all, the chairperson of the Research Commission on the Tax System, Liberal Democratic Party, former minister in charge of economic revitalization, Mr. Mari Akira. And Mr. Mari has been supporting the contents industry by setting up the Research Commission on the IP strategy. So, Mr. Mari, please.
皆さん拍手をお願いいたします。
Every year, I am very happy to come back to this seminar in conjunction with the Tokyo International Film Festival. And every year, MPA seminar is organized in line with Tokyo International Film Festival. And this is a very good occasion for film creators and also the consumers of films and other forms of creatives. And this MPA seminar is providing a lot of encouragement. Every time I take the podium like this, it seems to me Mr. Shintaro Ito is better suited to speak because he is on the side of creatives and producer. And however, I am invited to speak every year, as was mentioned by Mr. Murakami earlier, within the LDP, Liberal Democratic Party, contents creation, and also to protect the intellectual properties and utilize the properties. And people can share the creatives, and that would be able to remunerate those who produce contents. So we need that kind of very good digital ecosystem. So for that purpose, I am in LDP to promote such a digital ecosystem, and I organized a council for the first time in LDP, and I became the first chairman of this Intellectual Property Strategy Council. For this legacy or heritage, I am perhaps invited to MPA seminar. Perhaps my secretariat always gives me a script because they are worried what I am going to speak about. However, I always forget the paper behind me. That's why I always speak off the cuff. The other day, there was a long-term concern that is a piracy websites leading to illegal download. So we decided to have the illegalization of act of downloading prescribed in the law, and it took one more year than we expected. Actually, the Cultural Affairs Agency wanted to introduce this law earlier. However, in the final stretch, we had a very difficult debate. That is why it was delayed by 1 year. So people are worried that this law would expand the scope onto extraneous areas. Therefore, people concerned or people involved would have suffered the violation of their rights. So this is a sort of fake news which was spreading at the time. So I thought we have to set the scene once again. That is why we had to postpone the submission of the bill to the Diet by one session. However, we were able to get the buy-ins from all the people concerned, and we were able to have the law adopted in a very satisfactory and favorable manner. That means that the 1 year was not a waste. I think the 1 year delay was rather constructive. So the website-related issues, technical issues, and also fundamental countermeasures should have been introduced. That is to say, site blocking should have been introduced according to some. However, freedom of expression, secrecy of communication, there were several issues that we have to overcome. So we have to prevent the rampant online piracies. And there are many items that had to be discussed in the expert committee meetings. If everything else were pursued and no other alternative was not available, then site blocking should be introduced. So the contents, including the films and others, these are the creative product that only humans can produce. And that would in turn make our life more enriched and prosperous. So this is intangible values that are created, and that would in turn create a source of next chain of values to be created. So we have to duly understand this cycle. We don't want to be behind the curve. We don't want to be out of line with the international standards. But also, we prevented illegal camcording at the theaters, and the parliamentarians supported the bill to the Diet. And we are now be able to completely stop illegal camcording at the theaters. Now, we would like to make further contribution going forward for the good of film industry going forward. Thank you.
甘利先生。
Thank you very much, Mr. Amari. Next, I'd like to invite Mr. Shigeaki Tanaka, the Secretary General, the Secretariat of Intellectual Property Strategy Headquarters, such as Cabinet Office, which is indeed the control tower of the IP strategy policy in Japan. First of all, I'd like to appreciate my great thanks to the members of the Motion Picture Association for their daily support to Japan's intellectual property policies. In recent years, with the development of the digitalization, the market environment around contents have gone through the dramatic changes. Through the online internet distribution services, we can now enjoy the contents more easily over the borders. The Japanese consumers can enjoy the overseas contents in a wider way, and vice versa. The Japanese contents are also enjoyed by the consumers overseas. There are more and more opportunities for that. Now, under this COVID-19 situation, on the consumers' side, there is a change in how people work, but more and more people spend more time, free time, viewing the contents on the internet. And the supplier side, in order to respond to such a new demand, are starting to develop the new opportunities for a further business expansion. Now, even before the COVID-19, the development of the internet distribution has created some situation to bring about more damages in the market by the infringement of the copyright contents. Therefore, the Japanese government has put together the comprehensive menu and the process chart on the internet piracy, which was published in October last year. And based on this, the legislative actions have been taken. And as Mr. Amari mentioned earlier, in June this year, the revised Copyright Act was enacted, including the measures against elite site, as well as making the downloading of the static images illegal. And in October, the elite site legislation came into effect, and the download of the static images will be illegal in January. And we are now working on strengthening the communication so that people understand. And based on the Intellectual Property Promotion Plan 2020 in August this year, we have expanded the target for the disclosure of the senders for the provider liability restriction law, added IP addresses as well as the telephone numbers to make it easier to have civil actions, and furthermore, the smooth disclosure and court proceedings. The Ministry of International Affairs are now taking a necessary discussion. And it is also important to have an international cooperation to have a more stringent control over the illegal acts. And the government is also working on this with the counterparties. As for the administrator of the manga Piracy Site, which became a big news, we worked with the Philippines and also on the piracy distribution from Vietnam, now, which is drawing a great interest from the publishing company based on the memorandum on the cooperation of the copyright and adjacent rights in Vietnam. The Cultural Affairs Agency has asked its counterpart in Vietnam for a further collaboration on strengthening and controlling the piracy, and the Contents Overseas Distribution Association of the CODA is working with its counterpart in Vietnam for how to handle the infringed titles. We work with China as well, and also it's important to have some work on the private sector as well. So it is indispensable to have a support across the different sectors such as contents, telecommunication software, internet services, sharing the piracy site information, filtering service and security services, and the search services, such a collaboration and penetration of the authenticity mark, and education and awareness enhancement on the actions against the piracy is important. So the government would like to continue to support the cooperation with the private sector, and I ask for the continued support from MPA as well on this matter. I understand today's seminar is focusing on the site blocking, and as Mr. Amari explained earlier, and based on these comprehensive measures that I had just touched upon earlier, there have been various efforts and initiatives. And looking at the damages and loss, the site blocking is to be discussed going forward. We would like to smoothly do whatever we can at the maximum way, and working with the relevant government agencies to further promote the piracy actions. Once again, I'd like to thank MPA for a great support. Thank you very much. Thank you very much, Mr. Tanaka. Now, the U.S. Embassy is supporting this seminar, and I'd like to invite Mr. Steve Lang, the Minister Counsel for Economic and Scientific Affairs of U.S. Embassy.
Good afternoon, and thank you for the opportunity to join this important discussion today. The U.S. Embassy for many years has worked productively with the Motion Picture Association, the Japanese government, and many other stakeholders to promote the protection and enforcement of intellectual property rights. I'm honored today to share the stage with Amari Sensei, Tanaka Kyokucho, Ito Sensei, Chairman Ando, and I'm very grateful to have a chance to talk with all of our esteemed participants and those watching online. It was also a pleasure to see my old boss from his time at the State Department, Ambassador Rivkin. I'd like to commend Uni Japan on holding the Tokyo International Film Festival despite the challenges that the COVID pandemic has presented. We appreciate your efforts to continue this tradition and to find ways to promote new and innovative talent. Promoting innovation and intellectual property rights continues to be a top priority of the US government. The Department of State and its embassies and consulates around the world regularly have policy dialogues with host governments and multilateral institutions on this issue. Japan represents a valuable and trusted ally in providing strong intellectual property rights protection and enforcement. We appreciate how Japan has taken a leading role in promoting the expansion of these protections in its trade agreements with many partners around the world. In October last year, US Trade Representative Lighthizer and Japanese Ambassador Sugiyama signed the US-Japan Digital Trade Agreement. That agreement, which entered into force in January 2020, sets high-level standards for digital commerce that benefit trade, digital trade, and innovative products and services. Innovation generates demand and it drives our economies forward. The need for innovation has become even more evident as we look forward toward recovery from the impacts of the current pandemic. COVID-19 has accelerated the trend toward streaming as the preferred method for viewing video content. In 2019, the number of worldwide subscribers to streaming services surpassed the number of paid TV subscribers for the first time. Consumers now have the option of more than 500 licensed online portals to access movies, television, and sports. But alongside this boom in legal streaming services, we've also seen the growth and proliferation of illegal sites. The economic damage to legitimate commerce that these illicit sites do is staggering. I understand that each year there are over 26 billion views of illegally pirated US movies and 126 viewings of pirated US television shows. The impact of this theft of US digital entertainment is real and significant. It has cost the US economy as much as $115 billion of GDP and over 500,000 jobs lost annually. Costs related to digital theft of music, software, and movies globally are projected to reach $991 billion within 3 years. The United States and Japan must stand strong against the theft of intellectual property to protect our innovative economies. We must also educate our citizens about the hidden dangers of illicit streaming. Piracy poses many risks to consumers beyond the cost to content creators. We understand from many credible sources that piracy sites have increasingly turned to identity theft and malware distribution as an alternative source of revenue. For example, a 2018 Motion Pictures Association report indicates that piracy sites are 28 times more likely than mainstream websites to infect users with malware. Facing these realities, we must work together to pursue measures to minimize illegitimate access to content, while at the same time promoting the innovation that will nurture and generate new businesses. On behalf of the US government, I would like to thank and to reaffirm our commitment to the important policy agenda of this event today, and applaud the efforts of everyone attending to put these ideas into action. Thank you to the Motion Picture Association for providing this valuable forum to consider these difficult issues facing our country's entertainment industries. I look forward to hearing the many perspectives of the other participants today. Thank you very much.
Thank you very much, Minister Lang. Now we have the honor of having Mr. Shintaro Ito, the member of House of Representatives and the former State Minister for Foreign Affairs. He's been active in different fields, but for film industry, he's been supporting us as the Secretary General of the League of Members for the Promotion of Culture and Arts. So let me introduce Mr. Shintaro Ito. Thank you very much, Mr. Ito. He'll be giving us closing remarks at the end of the seminar. Now I would like to start the lectures. Those attending through the web, we can receive the questions from you through the mail address. If you have any questions about the speech or the panel discussion, please send them through this email. So first, Professor Nobuharu Obinata, the Professor of Faculty of Law, Kumamoto University, please. If you can come up on the stage, and please welcome him. Big round of applause. Professor Obinata, the floor is yours.
Thank you very much. I am Obinata. I am working at the Kumamoto University Faculty of Law. I am in charge of constitutional law. Thank you very much for giving me the opportunity to talk to the distinguished audience at 10th MPA seminar. In Japan recently, we have to pour all our energy into whatever we do. Therefore, today I will be pouring all my efforts and energy into this presentation. I will be fully concentrating on this presentation. As you know, so-called piracy on sites are giving damage to publishing industry and film industry. And this has become a big issue in Japan, particularly most recently, internet users can casually access comic, manga, pirated sites. And the emergence of such piracy sites has been reported as a big social issue. So these piracy sites, it is difficult to pinpoint the operator of the sites. Therefore, takedown notice or takedown claim and also the compensation claim is very difficult to achieve in a legal arena. So in order to respond to such online piracy, the government of Japan in April of 2018 introduced emergency measures for online piracy. Emergency measures has been proposed by the government at that time. So regarding the piracy site access, under the certain conditions, the ISPs are able to carry out blocking orders. Therefore, that policy was included in this emergency measures. However, this policy, right after its announcement, faced a string criticism from constitutional and information law academics and practitioners. The point is as follows. As a first point, the site blocking implementation would require a detection of access destination of internet users. However, under the Constitution and Telecommunication Business Act, or TBA, they guarantee the secrecy of communication. However, that right is to be violated by this. Secondly, this would block or blocking would violate freedom of expression. By blocking, that would give an undue burden on the part of ISPs. So these are the bases for constitutional and informational law academics to oppose this idea. Therefore, among this community, theory on the unconstitutionality of site blocking is prevailing. However, if we establish a law to allow ISPs to introduce site blocking, that would not necessarily violate the Constitution. That is my view. So this is the focus of my presentation today. Now, this point is to be illustrated by the following order or sequence. First of all, the law to allow the site blocking would not violate the freedom of expression guaranteed by the Constitution. After I talk about that, I would say such a law would not violate secrecy of communication guaranteed by the Constitution and TBA. Actually, today, for this sequence of the presentation, I have a particular idea because site blocking in relation to freedom of expression is not to violate the Constitution. Then in relation to secrecy of communications, this issue would be reduced to the issue of balancing of benefits. So the intellectual property right holders, their rights and benefits to be protected, that is more important than the lack of detection of access destination for internet users. Therefore, I think all we have to do is to compare these rights. So that is an issue of benefit balancing. And I would like to give you a final comments regarding the blocking is appropriate. Now, does blocking illegal or harmful sites violate the freedom of expression guaranteed by Article 21 of the Constitution? Let me start this discussion. Article 21, paragraph 1 is to protect all the freedom of expression in any form. Therefore, if ISP is asked to block sites that would violate the freedom of expression on the part of site operator. So that is one point. Then how will we go about with this? For example, under the Article 159 of Penal Code, obscenity is to be prohibited, and also under 230 Article of the Constitution, defamation and privacy of violation. That is a tort provision of 790 of Civil Code, and child pornography law. So this, the freedom of illegal expression does not exist. So it is not morally encouraged. So I think such a freedom of illegal expression is not relevant. Therefore, based on this, the pirated materials are illegal expressions violating the Copyright Act. Therefore, at that point in time, such a illegality may be rejected. However, I would hasten to say that the piracy site operators' freedom of expression is not to be guaranteed under the Constitution, Article 21. Therefore, such a freedom is not to be covered by the scope of the protection under the Constitution. And even if harmful and illegal expression in form, if that is to violate public policy or to defame famous figures, in that case, sometimes content of such expression may be illegal. For example, Article 232, and also that is the defamation of the public figures, and also privacy law. Now, is there any theory to reject the illegality of online piracy sites? Under the paragraph 21 of the Constitution, the freedom of expression of the expressor and freedom to know by the users are also protected. Then we cannot accept the freedom to view illegal expressions, not legal expressions. So that is because, for the following reasons, the internet users are able to see some expression because somebody has already uploaded that expression on the internet. However, if that uploaded expression is already illegal, then the viewers do not have the right to access such illegal expressions either. From January 1st next year, there will be expansion of scope of protection under the illegalization of act of downloading copyrighted infringing contents. Therefore, by the same token, we are not able to give freedom of viewing illegal expressions to internet users. Next question is, does access destination detection performed by the ISP to implement blocking violates secrecy of communication or not? The Article 4, Para 1 of the Communication Act, Telecommunication Act, says that secrecy of communication should be guaranteed. Therefore, the communication under the TBA, that third party wants to acquire the knowledge or divulge the information or against one's will for the purpose of others' benefits, unauthorized use of such information is prohibited. However, if ISP is to conduct blocking, then internet users' access destination has to be detected. Based on that, that information has to be used to block the site. So in that case, such a ISP conduct is to be done without consent of internet users. Therefore, without having consent from internet user, access destination information is to be gained. Therefore, ISP may violate secrecy of communication protected under that law. However, Article 4, Para 1, communication secrecy is to be contravened. However, I think there is a theory of inviolability. First point is public communication, open communication. So because of the demand of internet users, the information to be distributed on the internet is a public communication. Therefore, this is an open communication, not a non-public. Therefore, because the communication that has an open nature, such a access demand can be considered as open communication by nature. According to constitutional law, the secrecy of communication is to protect the content of communication of private nature, not public nature. Therefore, the access destination information is of a public nature. Even in that case, the demanding the access to that, whether or not that would fall into the category of open communication. However, communication can be divided into the content and also access information. Therefore, it seems that the protection covered under the TBA should be limited to public private nature. The next is ISP. In order to carry out their ordinary business, they have the purpose of mediating communication by others. However, the TBA prohibits the knowledge acquisition, diversion, and the unauthorized use only for the purpose of mediating communication of others. However, if the purpose is other than mediating communication of others, access destination information detection is only to mediate communication of others. Therefore, it is only limited purpose. So, Article 4, Para 1, TBA, the secrecy of communication should be protected, but only for the purpose of prohibiting knowledge acquisition, diversion, and unauthorized use for purpose other than mediating communication of others. Therefore, as I said, the non-violation theory or the justification by balancing benefits can provide the basis for legality of site blocking. So depending on media, I think the interpretation of the law should be restricted. Also, mechanical detection non-applicability theory. So blocking, so the mechanical detection, automatic detection of information would violate secrecy of communication according to some people. However, the internet environment, particularly secrecy of communication, is it really relevant? Now, the target of secrecy of communication protection covers not only content, but also constituent information, that is to say dates of sending information and sender information. They were considered to be covered by that scope. However, there has been no clear ground for these constituent elements to be protected. If the purpose of the secrecy of communication is to protect content of communication, there is no reason to include the constituent information, such as access destination, is to be included. However, by knowing access destination, one can guess what would be the content of communication. However, in that case, if there is no intervention of human perception, even if the constituent element is to be acquired, no one can guess who the other party is.
And also, the grounds for the secrecy of communication may be related to the privacy. If you interpret it that way, then the presence of the communication itself, I think that includes the requirements of the constituents. If then that should be also covered and protected. But the privacy, if it is related to the personal matters from the legal perspective, then the mechanically detected information, the action of linking that to the personal, private privacy does not exist online. And if we say that the privacy is indeed the area for the protection, then as long as we have the control, the management in place, then the information use should not be deemed as violating the secrecy of communication. Therefore, vis-a-vis the grounds of the secrecy of the communication, what would be the infringing, violating actions? Then, without going through the knowledge of people, if the information can be automatically detected mechanically, if that is deemed violating the secrecy of communication, that should not be appropriate. Mechanical and automatic detection falling under the violation of the secrecy of communication. It seems it's only one legal interpretation. So the blocking by ISP, if it's not convincing enough to have this non-infringement, then there is still a possibility of violating this Article 4-1 of the Telecommunication Business Act. In that way, how should we think? Well, now, back in 2010, the government put together the comprehensive measure to eliminate the child pornography. And on the pornography online, ISPs are site blocking, and the target contents for the Child Pornography Act stipulated under the Act. And in implementing the site blocking, then ISPs have to detect the access destination of the users, and they need to use that information for the site blocking. So that could violate the Article 4-1 of the TBA. If that is deemed a violation, then Article 179 stipulates the penalties for Sb Isps. I won't go into the details here, but ISPs voluntarily action against the child pornography is deemed as emergency responses for Article 37 of Constitution. And Article 37 as a requirement for the emergency. First of all, life or physical or assets, there is a high risk, potential high risk for those. And secondly, in order to avoid such a risk or damage, this kind of action should be taken, such as supplementary. And third, the loss should not exceed what was causing that. And the internet child porn access to be blocked by ISPs. The first requirement, non-subject child rights to be infringed and to be expanded if that's such a risk. And the second requirement, even under the requirement by the police for the deletion, if there is no deletion, as a supplementary requirement. And then the third, through this image of the child pornography, there is this infringement that would exceed the loss of the secrecy of the communication. However, the blocking against child pornography, there is a question about making it legal, because this emergency evacuation is only just a one-off act that is assumed. However, the blocking is not just one-off, it's a permanent measure. In relation to that, for the specific cases, the emergency evacuation should be discussed, but the blocking is done on a permanent way. But the blocking not based on the law is possible against child pornography sites. In other words, Child Pornography Prohibition Act prohibits the contents of the child pornography, and then the distribution, the freedom for expression cannot be accepted. Therefore, the freedom to view that cannot be accepted. Therefore, if such contents are left unattended, then that could bring loss or damage to that particular child. Then, in order to reach a reasonable conclusion, then the child protection, this benefit as a result of the blocking, if the compared to the freedom of not to be detected for the access, it's the benefit on the child is bigger. So such judgment was made as from a policy perspective, and I think the same applies to the pirated blocking. The freedom of expression or the freedom to receive or view, and as long as those are not accepted, then if other measures are not effective, then the intellectual property, the copyright holders, in order to protect the interest of the copyright holders, and then with the law to restrain the telecommunication should be possible from legal perspective. So mechanical detection for the purpose of blocking, and the disadvantage of that will, at the end, compared to the benefit that will be brought to the cultures and arts of our country, it's not necessarily a bigger. Now, for the remaining of my time, I'd like to touch upon several discussion points. Thus, identifying the pirated material fall under the censorship prohibited by Constitution and the Telecommunication Business Act. First of all, as I mentioned at the outset, the government's emergency measures, especially for malicious pirated site, is identified and asking ISPs to block it. And such procedure, whether they fall under the censorship or not, is another issue. On this point, based on the definition of the ruling by the Supreme Court, the comprehensive and individual request and not having an effect of public announcement, then those are not deemed as censorship. Based on this definition of the Supreme Court ruling, then identifying the pirated contents would not be falling under the censorship, because whether it's subject to blocking or not is for the home of expression, whether it's consistent with that, and not based on the contents of the ideas. And the copyright holders, well, it should be based on the individual cases of whether it could rescue the copyright holders, right? Moving on to the next point, is blocking. If a blocking of the pirated material is permitted, wouldn't that enable the blocking of defamation, violations of secrecy, and violation of rights of publicity? There is a slippery slope theory. So originally, it was used for the issues on the bioethics, but blocking the pirated site could trigger the opportunity to allow the blocking for the illegal and harmful expressions on the online. So that could so those sites uploading the defaming expressions violating the privacy, or expressions violating the rights to privacy, they could also be blocked. But I think it's groundless concern, because the defaming expressions violating privacy, and expressions violating the rights to publicity, for instance, for criticizing the public figures or have some cultural values or to promote the competition, there are such values serving as a brake on promoting them. However, there is no reason to protect this upload for the pirated sites. So justifying that. So those sites uploading the defaming expressions that cannot be justified. And the blocking with the authentic one in the expressions, if the same expressions are used, then the blocking should be done. It's not necessarily looking into the contents of the expression. So that could be a stopper for the site blocking scope. And last but not least, can ISPs be obligated to perform blocking for the piracy? ISPs are not necessarily the main players for the illegal act. Then how can we make ISPs obliged? Provider Liability Limitation Act in 2001, if we follow that, then in the services such as internet, we can disseminate information around the world. However, with the distribution of information on the internet, the telecom players are the bottleneck. Therefore, taking this as a unique characteristic for internet, then this Provider Liability Limitation Act vis-a-vis the illegal and harmful expressions beyond the operators, there is this legal component require stipulated in Article 3, a limitation of the request for the loss compensation, speech infrastructure, the responsibility of the intermediary or the responsibility of the platform. However, this Provider Liability Limitation Act, with the conventional interpretation, the common carriers, telecom service providers, on the contents of the information sent by others, the telecom carriers are held responsible. If it's a common carrier, then they have to provide the service to everyone. But with this act, for the expressions with a certain contents, they ask the providers to delete such contents. As a legal theory, how can that be justified? On this point, the public order to be set by the government on this public communication, that's how I take this Provider Liability Act. What the government set as an architecture based on the laws, we make a living. And vis-a-vis the secrecy of communication, then in the physical space, if the telecommunication only takes a physical form, then the secrecy is just on a one-on-one communication and the secrecy on that. But to fully protect that as a public order on the expression to be viewed as value, therefore, some threatening communication has some well, now that the internet is deemed as a big means of telecommunication in the country with the freedom of speech, then we if we see the telecom providers as a common carriers in this physical space, this legal grounds is no longer valid. So blocking the access to the piracy and whether we can ask ISPs to do that, if I go back to that, now that there is this infrastructure, then the conventional secrecy of communication cannot apply to this online no longer. As long as the piracy exists on the internet and as long as it's possible to access that, then this internet as a platform for expression is not appropriate. Based on this Freedom of Legal Act and the Civil Code Article 90, in order to maintain the assets order and the ethic orders, that provides the grounds for making a revision. So public order with the legislation can be maintained. In order to maintain the public order, the obligation is put on all the related stakeholders. Therefore, to maintain the public order of the internet, then the obligation is held on all the stakeholders, including the ISPs. If you take it that interpretation, then blocking the access to piracy and to require that to ISPs to maintain the public order and the obligation on ISP can be legalized. Then in that sense, in the speech infrastructure, the responsibility of the intermediary can be stipulated. That concludes my presentation. Thank you for your attention.
大湊先生、どうもありがとう。
Thank you very much, Professor Obinata. Please send him another round of applause. Thank you very much. Next, attorney at law from Germany, a partner at Nordman Law Firm, honorary professor, Humboldt University, Professor Jan Nordman will give us a speech. Dr. Nordman is attending remotely from Germany. Can we see him on the screen? It's 6:30 in the morning in Berlin. Professor Nordman, good morning to you. Thank you. And the floor is yours.
Yes, a warm good morning from Germany. Indeed, it's 6:30 in the morning here. I've been attending this seminar since 5:30 in the morning German time, but it's a great pleasure to be here, although only virtually, of course, in Japan. It's always been a great pleasure for me to visit Japan, which is of course not possible this time. So I think we take the second best option, and I join this great conference virtually. First of all, I wanted to thank in particular the MPA for inviting me to this event. It is of course a great honor and pleasure for me to give a talk on the constitutionality and legality of piracy website blocking in the EU and Germany for the 10th MPA seminar on the 33rd Tokyo International Film Festival. And a particular good afternoon as well to my fellow panelists, Professor Obinata, who has just given a great talk that I will also refer to, I think, for some points that I will touch, and of course also to Mr. Tohyama, who moderates this panel. It's a great pleasure to be on the panel together with you, although only virtually. Today, my today's topic is, as I already said, the constitutionality and the legality of piracy website blocking in the EU and Germany. We've already heard a lot of discussion points from Professor Obinata, which are current discussion topics in Japan at the moment, and I will try to give you some additional information on where the discussion is on site blocking and its constitutionality and legality in the EU and Europe. Let me start with the agenda. Starting with the agenda always reminds me of what a British colleague told me when I, gave a talk in Great Britain, and I started with an agenda. And he said, well, Mr. Nordeman, that's interesting that you start with an agenda, because British speakers would always start with a joke, while Germans always start with an agenda. So I think we will do it the German way, and I will present you what I will talk about. As you can see here, it is very important in EU law to know the starting point for website blocking, and that is the famous Article 8.3 of the EU Copyright Directive. I will show you in a minute what this is about. The second point on my agenda is the leading case of the CJEU on website blocking. There's also, that's the third point on the agenda, a leading case from Germany, from the German Federal Supreme Court. I have, as a fourth point on the agenda, some blocking orders from Germany, examples which websites are blocked in Germany through court orders. And I have some selected legal issues for you under 5, in particular regarding efficacy of website blocking, the so-called subsidiarity of website blocking. I will show you what this is about. And of course, I will discuss some constitutional law issues under the EU Constitution and under the German Constitution, in particular also regarding the issues that are under discussion in Japan that Professor Obinata has already told us about. And I will give you also at the very end of my presentation a short summary. So let's jump right into my presentation and the starting point, which is the famous Article 8.3. And that is Article 8.3 of the EU Copyright Directive, which came into effect in 2001. So it is already almost 20 years old. The text of Article 8.3 says, it is, as is also on the slide here, member states, EU member states, this means, of course, shall ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe a copyright or a related right. So what does that mean? There is a recital in the Copyright Directive which explains what is the content of Article 8.3. I will also read that out to you for a better understanding. In the digital environment, in particular, the services of intermediaries may increasingly be used by third parties for infringing activities. In many cases, such intermediaries are best placed, that's important, they are best placed to bring such infringing activities to an end. Therefore, right holders should have the possibility of applying for an injunction against an intermediary. And that results or says that there are helping duties of intermediaries even if they have committed no fault, if they have done nothing wrong, even if they are innocent, they have to help stop the infringements. That is the concept under Article 8.3. So the basis for this is helping duties, the ISPs help stop the infringements. As I said already when I introduced the agenda, there's a leading case in the EU by the Court of Justice of the EU, which is called CJEU, and that is the case UPC Telekabel Wien Konstantin was decided in March 2014, as you can see here on the slide. The CJEU ruled that site blocking in general is admissible under Article 8.3 of the Copyright Directive. And the CJEU again emphasized that access providers have a duty to take action for site blocking because they are best placed to stop the infringement. Yeah? So it is no requirement that they have done anything wrong. That is not a requirement. They are innocent access providers, but they have a duty to take action because they are best placed to take this action and to fight piracy according to Article 8.3 of the EU Copyright Directive. That leading case of the CJEU has led to widespread site blocking action in the EU and has led to most of the EU countries having established a site blocking regime in their country. On the slide here, you can see how many countries in the EU have implemented site blocking orders. And it's the vast majority, as you can see. There are some Eastern European countries that do not have site blocking yet, as you can see in the map, which is in most of the times because there are no cases yet brought. Yeah, so the courts did not deny site blocking, but there are simply no cases. So I couldn't color those countries in the map. But those countries where site blocking action was brought to the courts have more or less all recognized site blocking and have implemented it. As you can see here, Germany among them, which is in the middle of Europe here. The first country, by the way, to implement site blocking was Denmark, then followed by Great Britain. Yeah. But the Germans have it as well. There's a leading case also by the German Federal Supreme Court, the so-called BGH, and that is Störerhaftung des Access Providers. That is the case name. It's a very long German name, I know. You do not have to try to pronounce it. It's very difficult to pronounce. So maybe you better refer to the number of the case, which is 1ZR 174 out of 14 decided in 2015. And the German BGH said that site blocking is also generally admissible under German civil law. The legal doctrine is the so-called Störerhaftung, which is literally translated liability of the disturber. It is a civil injunction claim, and you have to notify the ISP about your claim for website blocking, and after notification, there is a claim, civil claim, that the ISP implements the blocking measure. This theory for website blocking was changed in a second German BGH case called Dead Island, about the computer game you may know, Dead Island, that was subject to this case. The legal doctrine was changed from Störerhaftung to Section 7.4 of the German Telemedia Act, but otherwise nothing changed. The material requirements for website blocking did not change through the second decision. So now I wanted to show you some examples for website blocking in Germany. The first website blocking decision ever in Germany granting a blocking order by a court was the so-called Keynote.to decision in February 2018, which was upheld by the Court of Appeal Munich in June 2018. The site that was blocked was kinox.to, a website making illegally available thousands of films, including movies that are still in the theaters, still in the cinemas. There was one claimant. It was a German film producer, medium-sized German film producer called Konstantin, and it was about a German movie that was illegally up on kinox.to. The second case I wanted to show you as an example is also a Munich District Court case with two blocking decisions, one against Vodafone in German ISP Vodafone in 2018, and the second blocking order October 2019 against the biggest German ISP Deutsche Telekom. These blocking orders are against the websites LibGym and Sci-Hub. They are each websites illegally making available vast amounts of scientific books and scientific journals. The claimants were scientific publishers, for example, Elsevier and Springer Nature, which is the last publisher as a German publisher, but of course with an international repertoire. Now, after these examples, I wanted to touch some specific issues of website blocking, specific legal issues, and the first one is efficacy. In particular, the blocking measure of DNS blocking I wanted to discuss with you. DNS blocking may be circumvented, yeah? DNS blocking is, if you put it simply, if the user, the internet user, types in a domain name, the user will not find the website because the DNS blocks makes it impossible for the domain name to connect to the website the user wants to visit. So it may be circumvented, the DNS block, for example, by typing in the IP address directly for the user. So that was, of course, a great fear at the beginning that users who would face a DNS block would simply type in the IP address and circumvent a DNS block. But empirical data from EU countries show that this fear is not founded. As you can see here on the slide, for example, there have been empirical research in the United Kingdom which came to the result that the internet traffic dropped by 77% to illegal sites after DNS blocks were implemented. So people did not circumvent, at least most of them, 3/4 did not circumvent. More or less the same result for Portugal, according to another study. The internet traffic of the websites blocked dropped by 70%, 70% in 1 year. In Germany, that's also interesting, I think, empirical numbers do not have any importance. And that is because the German BGH, the German Federal Supreme Court, has said we don't need empirical proof in case you implement a DNS block, because the DNS block will at least lead to the users to think again. You know, it closes the path for access for the users and raises their understanding of acting wrongly. So no empirical efficacy necessary. It's just the raising of awareness of users to act wrongly, which is sufficient for efficacy, according to the German BGH. Of course, there are also other measures. I just wanted to mention them briefly. In particular, search engines have been obligated to de-index piracy sites. For example, Google has been obligated to index piracy sites by a French court in 2018, as you can see here. And of course, nowadays, Google also de-indexes piracy sites also voluntarily, as done in Australia just recently, and is shown here on my slide. There's another issue I wanted to briefly cover, and that's the subsidiarity of site blocking. That is a German requirement. Site blocking must be the last resort. Before going to the ISP and requesting site blocking, the right holder must have used all proportionate efforts to stop the infringements at the source. Yeah? So the right holder must go to the site operator, and this must have been unsuccessful. So reasonable steps against the site operator, unsuccessful. And the second requirement is as a right holder, you also have to take reasonable steps against the technical service providers of the piracy site, for example, against the host provider, and that must also have been unsuccessful. That's also the case law of the German BGH. So there you see it's a quite strict requirement. But in summary, of course, in the cases, it has turned out that the subsidiarity requirement can usually be met for sites with illegal business models without any prior court action against the operator or the host provider, as they will have taken precaution that no legal action against them is possible. They will usually hide, yeah? And they are, you cannot go after them. But still, you have to show this to the court according to the subsidiarity rule. Now I will come to the issues that I know are most interesting in Japan, and Professor Obinata has also touched upon upon them in his excellent presentation. Constitutional law issues. And the first one is the constitutional telecommunications secret in the EU and Germany. Of course, also the EU constitution and the German constitution have a fundamental right of telecommunication secrecy. That was also evaluated by the German BGH, by the German Federal Supreme Court, in its leading decisions. And the result was the constitutional protection of telecommunication secrecy was not touched, was not breached. And that's for two reasons. The most important reason why the telecommunication secret was not breached is that with site blocking, you do not block secret information, you block a website that is publicly available on the internet. According to the German BGH, the telecommunications secret does not protect public offers and their access, but it only protects individual non-public communication. There's a quote also I brought with me from the German BGH, which says, the starting point for the protection in Article 10, first paragraph, German Constitution, is always the non-public exchange of specific communications of participants. In contrast, communications addressed to the general public are not covered by this provision, are not covered by the constitutional telecommunications secret. So piracy websites that are offered to the public do not come under the German telecommunications secret if you block access to them. That's the first argument. The second argument why the telecommunications secret is not breached comes from the blocking measure at trial in the case, and that is DNS blocks. The German BGH said DNS blocks merely prevent that you access a site, but they do not look into secret communication. Yeah, they only prevent communication, but you do not look into secret communication. And that's also why the telecommunications secret is not breached. Let me go on with some other constitutional law issues which you may find interesting. Professor Obinata has also touched upon other constitutional law issues, and there are other, also according to EU and German law, there are other constitutional rights involved. For the right holders, it's their constitutional right to intellectual property. Yeah? What you have to bear in mind is that this constitutional right has a specific weight in site blocking, in particular under German law, because, as I said, site blocking is the last resort you have. You know, I showed you in my slides before, you have to try to go to the operator first and to the host provider of the piracy website first, and only if this fails, you can go to the ISP and ask for site blocking. So it's the last resort. There's nothing else to do. And if you do not do site blocking, there is no protection at all for the right holder. And of course, this weighs heavily in the German and EU constitution. For the access providers, it is the constitutional freedom to operate a business that counts, of course, in the weighing of the constitutional rights. And for the internet users, it's the freedom to access information. That was also mentioned by Professor Obinata in his speech. And then you have to do a weighing of constitutional rights. And I will show you how this works in practice. For example, the right to information by the user, which is protected in the German Constitution, Article 5 and Article 11 EU Charter of Fundamental Rights, which is the EU Constitution. For example, you must not overblock with site blocking. That's the general rule. But illegal content does not count. That is the same as Professor Obinata highlighted in his presentation. He also came to the conclusion that there is no constitutional right to access illegal content. Same result in Germany and the EU. The problem is always legal content. Yeah, there's always some legal content on the piracy sites. For example, the users may comment on a movie and say, oh, this is a good movie. I can only recommend everybody to watch the movie. But the movie is, of course, illegally up on the site. But the comment, of course, is legal. The German courts and also Swedish courts have said, well, you have to look at the relationship between legal content and illegal content. And if the vast majority is illegal, you can accept that you block a small portion of legal content. The German Federal Supreme Court, the German BGH, specifically said 4% illegal content is tolerable, is allowed if 96% on the piracy website is illegal. And one last note on the constitutional right to information for users. The EU, the CJEU, and also the German BGH have both said that internet users must have a right to sue the access provider to lift overblocking, site blocking that constitutes overblocking. So there's a legal remedy for internet users for their rights, which also flows from the Constitution. And that's already the end of my presentation and the summary. To summarize the basic content of my presentation, site blocking in the EU and Germany is rooted in Article 8.3 of the EU Copyright Directive. Again, said the ISPs have a duty to block, not because they have done anything wrong, but because they have to help. They have helping duties. The CJU has recognized this in the leading case UPC Telekabel Wien Konstantin in 2014 already, and the German Federal Supreme Court has also recognized website blocking under German law and has clarified the most important open issues. The first website blocking practice in Germany shows illegal sites with film content and with illegal scientific content. Blocking measures like DNS blocks are efficient both from an empirical standpoint and from a legal perspective, according to the case law in Germany. According to the German BGH, site blocking claims must be the last resort if reasonable legal steps against the site operator and its providers were unsuccessful. That's the so-called subsidiarity requirement. Sites with an illegal business model will usually meet this requirement of subsidiarity. Constitutional issues. The constitutional telecommunication of internet users, and in particular the constitutional telecommunications secret, does not pose a problem, as I've shown you, in Germany and the EU. The German BGH has emphasized that the weighing of constitutional rights must take place when assessing proportionality. You have to weigh the rights of the right holders, right to intellectual property, of the access providers, freedom to operate their business, and of course also of the internet users and their freedom to access the information. You have to weigh these constitutional rights, and one of the results of German case law is that there is no infringement of the freedom to access information if a piracy website is blocked, which predominantly consists of copyright infringing content. And that's all from my part for now. Best regards to Japan. I'm really so sorry and sad that I cannot be there in Tokyo today at the film festival, but thank you for listening to me, and I look forward to the panel discussion now.
ノードマン博士、どうもありがとうございました。皆様、盛大な拍手
Thank you very much, Professor Nordman. Please send him a big round of applause. So next is a panel discussion. Please give us some time to change the stage setup.
どうもお待たせいたしました。
Thank you very much for waiting. So I'd like to move on to the panel discussion. Let me introduce the participants. So if you can come up on the podium. Mr. Tomohiro Tohyama, please come up on the stage. Professor Nobuharu Obinata, please. And Mr. Jan Nordman will be attending remotely. So we ask Mr. Tohyama, the partner at TMI law firm, to serve as a moderator. Mr. Tohyama is a partner and attorney at law at TMI, one of the founding members, and he's been heavily involved in the copyright protection of the major film companies and also in various entertainment business such as filmmaking, sports, and music. So we ask the web participants to also send the questions through the mail address. So I'd like to pass the microphone to Mr. Tohyama, please.
I am Tohyama, attorney at law, and there is one thing missing from my introduction earlier. I am the first representative of the Japan chapter of MPA. It was established in 1986, and since that time, the protection of intellectual property rights, this is my life work over 30-some years. Now, thank you for your attendance today. Professor Obinata, Professor Nordman, we had a very detailed presentations, very illustrative presentations. Thank you for that. The time given to me is 30 minutes. So in this panel discussion, we would like to have discussions so that even junior high school students can understand. We would like to clarify the issues, and also we would like to have people understand. We had Minister Lang from the U.S. Embassy, and he talked about how damaging the current online piracy is. And the numbers were cited. In Japan, internet online piracy in Japan today, the number of sites, 2,772 sites, and on a monthly basis, about 280 million accesses seen. So for each of these accesses, if we are to respond separately, it would be so burdensome and so difficult. I think that is easy to understand. Now, we had two eminent speakers today, and they talked about the secrecy of communication and the freedom of expression. And so people understand that there are some problems with online piracy. However, as I said, even for junior high school students, I think this can be understood. So we would like to have that in mind in having discussions amongst three of us. Now, freedom of expression and the secrecy of communication. These are the constitutional issues. Article 21 of the Constitution, paragraph 1, is about the freedom of association, publishing, and other freedom of expression is to be protected. And likewise, in the paragraph 2 of this article, censorship should be prohibited. Secrecy of communication should not be violated. So in relation to this, under the TBA, Article 4, the telecommunication operators, during their business, they should not violate secrecy of communication during the business. That is the rules under the law. Now, starting with the secrecy of communication, the first thing we have to understand is, so maybe there is a secret here. Now, secrecy of communication, when we discuss site blocking, we often use the word DNS blocking, domain name system, DNS blocking. More simply said, the illegal sites, site name. For example, X illegal theater JP, for instance. In that case, the user X illegal theater.jp, if this name is entered, the internet would understand this person wants to get access to that site. Only that access information. For instance, if you want to go to Mitsukoshi department store, you type in that name and you can be guided wrongly to other place. So, and then the next stage, X illegal theater JP, that name, is it secret or not? That is the next question.
Can you hear me? The voice.
Sorry, I was on mute.
Okay, let me start with a question. The point I just made is the name of domain. Is it private or secret? I think you mentioned that it's not the private or secret information. It is a system to be publicly offered. Could you just explain about this secrecy?
Yes, that is a good question. So of course, I mean the domain name of a piracy site is not a secret. Yeah. For example, take probably the world's most famous piracy site, the Pirate Bay, it is called. It's been up on the internet for many years. It is not a secret to anybody, and in particular not to junior high school students, I think. So it is publicly accessible, the website. It is offered to the entire world. So at least according to the German Federal Supreme Court, the German BGH, preventing access to this website through a DNS block does not come under the telecommunication secret, because the website is nothing secret. It's open on the internet.
Thank you very much. 今の通り
So as was mentioned just now, the illegal site's domain name, this is known to everybody. This is publicly offered, so it's not a secret at all. Therefore, another concern would be those who are accessing there, the information related to such internet user trying to access.
part of the private information of the person who is making access is stored or made use of?
Yeah, that is also a good question. That is of course, the second thing you have to look at is maybe the fact that the user wants to access the pirate site. Is that a secret? But for example, with a DNS block, you do not store this data. You just make it impossible for the internet user to access the site. But the ISP, by implementing the DNS block, will not know that the user tried to access the site. Yeah. So preventing the access to a site, also at least according to the German BGH, does not come under the telecommunication secret, because you're not looking into the request to access the site, but you're only preventing him to do it without storing the data or so.
Thank you.
Thank you. So Professor Obinata, what I started was originally, when it comes to DNS blocking, illegal sites, a domain name or host name is simply detected. And the access side, there's an action of trying to access, but information about me is not known. Information about me is not stored. Is that correct? Yes. Well, I'm not an expert on the IT system per se, but that's what I presume. So what is infringed as a secrecy is something I'm having a hard time understanding as well. Now, DNS blocking is something that I've been following for several years. But what is the secrecy here? I may be wrong, but with this blocking, what we know is that what you're trying to access may contain xillegal.jp or whatever, whether that is included or not. That's the only thing. And if you search that, then you get guided to a different site. That's all about it. So if I try to access who am I and what's my mail address, those information will not be known. In that sense, nothing is secret, is my conclusion here. Now, when it comes to secrecy of communication, when you hear secret from kindergarten, elementary school, junior high, you may have wondered what is secret. So when we think about the secrecy of telecommunication, then the constituents of secrecy to be known, to acquire, and to use it. And the first hurdle is the structure of the secrecy in infringing the secrecy of communication. Then the structure, this domain name of the legal site, is that a secrecy? Everyone knows that it's this particular film, and 280 million people can access this site on a monthly basis. As Mr. Norman said in his agenda, it's a public offering. Please come, please come. So it doesn't seem it's a secret to begin with. That's how I strongly feel, with some confidence. Now, how about censorship? In relation to that, I'd like to move on to talk about the censorship. Professor Obinata, when it comes to censorship, well, I was born in 1950, and even now, in different dramas, we see what was happening before and during and after the war. The Imperial Japan with the army force censoring the letters or wiretapping the telephone conversation. So when it comes to the censorship, it seems like it has something to do with the secrecy or secret things. What do you think? Well, it's not necessarily about the secrecy, but the contents. The contents of the expression, contents of the communication is not favorable. So that's where the censorship comes in if you're not allowed to make certain expressions. So Professor Yang.
Kind of inspection, inspection of envelope or letter or a telephone call. The site blocking has any bearing or infringing element in this kind of an inspection?
Yes, I think, Mr. Tohyama, that very much depends on the blocking measure we're talking about. When we're talking about DNS blocks, for example, as you've pointed out rightly, we are only talking about making it impossible to access a certain site. So you're not looking into any communication, you're just making it impossible. You're blocking it away, yeah? But you're not looking into anything. You're not looking into a letter, you're not looking into an envelope or so. There are other blocking measures, such as filtering, deep inspection, where you look into the communication and you filter out the communication you don't want. Here, maybe, it is a bit different. But, in particular for DNS blocking, I would strongly advocate that there is no problem with, censorship looking into communication, because as I said, it's not about looking into communication. That's not the case. It's more of making it impossible, preventing it. That's a big difference, I think.
Thank you.
According to the explanation just given, the content is not seen. So simply the making it impossible to access the site one wants to. However, the censorship is to know the content and use it for other purpose. Therefore, the content is not shared. So I think there is a slight similarity here. From person A to person B, there is a letter. Take this as an example. And person B sends a letter to person A, and the envelope surface would say the A's name and address. Then the envelope is not opened, but still the person A's name and address can be known. So just like this, maybe this is the same or different from what we are talking about. Perhaps person A's name and address is publicly known information. From person B to person A, when the letter is sent, and this is a private communication, but compared to this, site blocking, the target of site blocking, that is illegal websites, domain name, is it just like the person A's name in the letter case? It is clearly different. It's different because illegal site is publicly offered, and illegal sites are saying this is a publicly offered illegal sites. Therefore, it is not a communication between two private persons.
The communication between the illegal site and the person who wants to make access, it's not a private or individual communication. Could you elaborate a little bit upon that? Oh,
Yes,
I should say,
I think
compared to a person B writing a letter to person A, both are so private and individual, totally different from the thing that we are talking.
Yes, I share this view, and I think your example is very good of, from the old world, let's say, of writing letters. So this is not really about DNS blocking. It's not about writing a letter from one individual to another individual, but it's rather of you going to a public place, yeah, because the website is public. It's nothing secret. Yeah, it's open on the internet. And DNS blocking is about building a wall so that you cannot go further. That's all. Yeah, that's all. You're prevented from accessing the site. You're preventing from going there. That has nothing to do, I think, with a secret, because it's also, as I said, DNS blocking does not store the information that you wanted to go even. DNS blocks just tell you, you cannot go. And that's all that happens. It doesn't store the information even that you wanted to go.
Thank you very much.
So in Professor Norman's presentation, he mentioned last resort. It's not the resort town, it's a last resort that you can turn to. So going through various steps necessary as a last resort, site blocking should be available. So that was the explanation given. Then what sort of steps do we need to go through before we go to DNS blocking? So what would be the reasonable necessary steps in order to go to that last resort of DNS blocking? So let me ask him on this question.
But this site blocking should be the last resort. And the one who owns the copyright has to take the reasonable steps before taking action at the site blocking. Could you possibly spell out some concrete steps that the copyright holder has to make?
Oh yes, I will be very happy to do so. Indeed, this is a requirement that the German BGH has provided, the so-called subsidiarity last resort. Yeah. So, for example, you have to go to the site operator of the piracy site and say, you have uploaded my movie illegally to your website, please take it down. In a lot of cases, that is impossible because you will find nobody who is responsible. There is no imprint, there is nobody responsible on the website. You cannot even send an email to the website. There is no contact information on the website. But if there is a contact information, you have to send an email, yeah, and demand takedown. Another example would be that you go after the hosting provider. You write an email to the hosting provider and say, my movie is illegally up on the piracy site. You are hosting the site. Please take my video. Please take my movie down. And in case the takedown happens, no site blocking is necessary because the takedown was made and the problem has gone away. That said, for piracy websites, usually they choose a hosting provider which is so-called bulletproof. Yeah? So they choose hosting providers that do not respond to takedown requests and that are far away from, far away enough for enforcement, for successful enforcement. As I said in my presentation, usually piracy business models, you have no other last resort than site blocking because their business model is already made that they will not respond to takedown requests. And that includes their service providers, such as the hosting providers. So this last resort theory leads to site blocking only being available in Germany for piracy sites. And it's not available for sites that you can reach and that you can go to court against.
Thank you very much. 表現の自由の問題に行く前に一つ
Before going to the freedom of expression, just another point, as Mr. Yang mentioned, student hafting or student hafting. Hafting means a liability in German, and Stühler means disturber. So disturber, who is a disturber is what I wondered. Is it ISPs who are the disturber, or is it someone trying to access? So I wanted to clarify that point.
The word Störer Haftung. The Haftung means liability, and the Störer is disturber. Who is disturber? Is it an ISP?
Yeah, that's a very good question. And first of all, thank you so much for pronouncing so well the difficult German word, Störer. Indeed, I think the term is not 100% correct used in Germany. Because the ISP is not a disturber. Yeah, the ISP has done nothing wrong. The ISP is innocent. The ISP has a duty to help. So it is more, it would be if you translate it better, it should probably read liability for the helper, yeah, and not for the disturber.
Maybe liability of intermediary.
Yeah, or to put it neutrally, right, liability for the intermediary, although I must also say maybe liability is too strong as a word, because liability would also include damages. And of course here for website blocking claims against ISPs, we are not talking about damages, we are only talking about injunction, yeah, duties, only about the blocking duties as such. And maybe the word, I don't know, responsibility is better, or some scholars also use the word accountability and not liability, because that may be, as I said, too strong as a word and include damage claims which are not under discussion against innocent ISPs.
Thank you. Disturber というね、disturber
Thank you. So disturber. Well, ISP should not be deemed as a disturber, of course. Now, intermediary is someone to come in between, and ISP as an intermediary between someone trying to access and someone operating the illegal site. I think that may fit better. Now, coming into the freedom of expression, not many of the constitutional scholars, but talking about a violation of the secrecy of telecommunication or the freedom of expression. But once again, let's go back to the junior high mindset. Well, I want to kill X. And if I write it on the internet and I specify this X by a specific name, I want to kill this person. This is an expression. So under the Constitution, that's extortion. It's not an action of killing yet, but it's just threatening. I want to kill person X. This expression that I put on internet, can that be protected by Constitution Article 21, freedom of expression? Illegal site operator saying that I'm operating the illegal site, or someone who wants to access, willingness to access, this expression of wanting to access. Maybe those cannot be defined. Professor Obinata, not just the scholars, but even the lawyers say this may violate the freedom of expression. What do we mean by the freedom of expression on the internet or the illegal site? That's my big question mark. I have a question mark around that as well. My point is there should not be a freedom of expression for the pirated site. There should not be a freedom to view or know about the pirated site. So any defamation expression or it's the same about infringing the copyright, and that cannot be accepted. Now, there is some discussion about overblocking as well, where there is some legal part as well. So that could be true that there may be some legal part, but in the conjunction for the magazines, for instance, not just the illegal part, but the entire magazine publication is conjuncted. So it's the same thing. It's not just the issue unique to the site blocking. But that should be able to be clarified with this current discussion.
Talking about freedom of speech, and for me, it is so unthinkable to think of any freedom of speech in relation to illegal site. I said to the audience that if I either make a sentence in the internet, I like to kill X. It constitutes a criminal act of threat. It's not a start of the murder, but do we have to protect my message? No way. So I don't think of any value to be protected under freedom of speech, in the context of the illegal site. Maybe that in Germany or EU, this freedom of speech issue, is not an issue at all, I guess. How is it?
No, indeed, I share your view. And I can tell you, it's not an issue when it's clear copyright infringements. Would not come under freedom of speech, and would also not come under the constitutional right to information. Yeah. There is no constitutional right to act illegally. Yeah, and to express yourself illegally, and so the illegal content is out of the constitutional assessment. You have to take into account, I mentioned that in my presentation, the remaining small legal part of content on the blocked site.
Thank you.
So on the websites, those of you who are watching websites and the constitutional scholars and practitioners who think that website blocking would be violating the freedom of expression. If you think so, please contact me by email to give me your arguments. It thinks that there is nothing to be protected when it comes to illegal contents. The xillegaltheater.jp, this kind of illegal site. And they are doing something illegal there. And then there is nothing to be protected when it comes to their expression. Therefore, in Japan, I think that the Professor Obinata has to play even greater role. I think Professor Obinata, other names, I know some. I mean the experts, scholars, and lawyers, and I know them. But on what basis do they say this is a constitutional violation? Well, because we don't have much time for this discussion, but let me say, I think the violation of secrecy is their view, because in Japan, the child pornography was blocked, but in that case, they only say evacuation, emergency evacuation, in order to avert imminent danger, and that is why illegality can be denied. So even in that case, there is something to be violated there. But as Mr. Tohyama said, yes, it is true that access destination domain name is publicly offered. Therefore, those who are accessing that there is no secrecy. However, constitutional experts say that the fact that they are trying to access that site is a secret. So although the address is publicly known, but the fact that I am trying to go there is a secret. Therefore, in the case of child pornography, that can be denied because there is an imminent danger. However, when it comes to site blocking, the secrecy of communication is even more important. Maybe that is true to some extent. However, maybe there is a freedom of not to be detected mechanically to some extent. However, I think that the benefit outweighs the negative impact that they are speaking about. However, the fact that somebody is trying to access that site, that in itself is a secret, according to them, in my view. As I said earlier, when I want to access that site, the name, domain name, and also the fact that I am trying to access that site, that personal data is not stored at all. Therefore, getting a knowledge isn't involved in that site blocking act. So I would be redirected to a different site only by site blocking. So I don't think there is a problem in my view. So including administrators, governments, and there is an Article 4 Telecommunication Business Act in relation to secrecy of communication. That's why people are worried. However, if you look at what's happening through site blocking, there is nothing like acquisition of knowledge, divulging knowledge, and also the use of the information for other purposes and so forth. I think this is easy to understand even for junior high school students. So listening to two professors, I think this is very clear-cut for me. And I did my homework, and I've learned very much about these issues. And I think I had a very clear-cut conclusion. So let's finish.
Discussion. 小宮先生、どうもありがとうございました。
Thank you very much, Professor Obinata.
ありがとうございました。
ありがとうございました。
どうもありがとうございました。
Thank you very much. Next, we'd like to move on to the Q&A session. So those who are sending the questions through the email address, those attending online, well, we received a couple of questions, so I'd like to address those questions first, and then after that, I'd like to open the floor from the audience here. Now, a question to Professor Obinata. There's a question through email. In Japan, the site blocking is said to infringe the secrecy of communication according to some people. Has this kind of idea become a norm already in Japan? Well, in Japan, the secrecy of communication among the constitutional scholars, there had not been much research done so far. But when it comes to the piracy blocking, then all of a sudden there is a great level of attention paid. Then from that perspective, what would be the definition of the commonly accepted theory is one thing, but rather than the number or the head count, but the very eminent scholars say that it might be against the secrecy of communication, it might be against the Constitution, rather than this becoming a commonly accepted theory. Thank you. So in relation to the secrecy of communication, there's a question to Professor Nordman as well.
By email, in Japan, site blocking is said to violate the secrecy of communication according to many experts. This way of thinking, from the viewpoint of international perspective, it is very unique to Japan, or is it a commonly accepted theory in the international arena as well?
Or should we
Yes,
first?
please. Go ahead.
Yes. So according to my view, at least in the EU member states that I can oversee, the German view on the constitutional telecommunications secret is shared by other EU countries. You have seen the map in my presentation, and all major EU member states like France, Spain, Italy, the United Kingdom as well. They are leaving the EU, but they share this view as well. France, did I mention France? The Benelux countries, they all think that the constitutional telecommunication secret is not a problem. It is rather a problem of, access of information is a constitutional issue. You have to weigh that with the constitutional rights of the right holders and of the access providers, of course. But the constitutional telecommunications secret is not an issue because, as I said, we're not talking about a secret, a breach of a secret in case you DNS block, for example.
どうもありがとうございます。
Thank you very much. That answered the question very clearly. Now I'd like to open the floor for the questions. If you have any questions in this venue, those who are here physically, if you have any questions, please raise your hand. I will bring the microphone to you. Yes, please. If possible, please identify your name as well. Uchida from Tokai University. Thank you very much to all the lectures. I learned a lot from your presentations. I have some clarifying points or questions. So please allow me to take a seat. So the first point, rather maniac question, but I wanted to learn here. My first point, Professor Obinata, page 7 of your presentation materials, for the having the open communication, there's a question you said, but in the panel, whether it's a secret information or telecommunication or not, you mentioned that it's not deemed as a secret communication. So how can I reconcile this? How do you define this communication which is open and vis-a-vis the secrecy? If you can elaborate. Well, on that point, I didn't want to spend too much time in discussion. That's why I didn't go into the details. But this open communication, Edward Ed plus, that's what this URL. If it's in a URL, then it's open communication. But this act of trying to access that, access request, my theory is that it's not necessarily deemed open just by trying to access that URL. Then IP address that you're trying to access, this IP address, or user sending the information to URL, and that part can maybe viewed as a secret information. In the case of the letters, for instance, between person A and B, the letter, B sending letter to B, A. A's address is open, but B trying to write a letter to A, that's a secret.
I have next question. Once again, I ask this for clarification in relation to emergency evacuation, child pornography, the freedom of expression. In that area, you mentioned the right to know, right to view, according to page 5. The intellectual property law discussion would say that the viewing the site itself would not violate the freedom to know. However, possession and also distribution of child pornography is to be prohibited. However, the viewing child pornography is not to be prohibited under the law, I think. What is your view? Well, in my view, child pornography is similar here because if child pornography is there, there is a benefit of looking at it. However, uploading that is illegal. That is why there is no such thing as freedom of viewing the child pornography. Maybe there is a benefit, oppositional benefit. If the uploading is illegal conduct, then I think we should consider oppositional benefit as well. So you have to download illegal child pornography in order to view. So that conduct itself is illegal, in my view. Well, I think I can go along with that way of thinking. So that is why I just wanted to confirm.
先生と帯名先生
Now, a question to both Professor Yang and Professor Obinata. Professor Obinata, on page 13, the role of ISP and Yang Sensei's documents about the Strehakten. Professor Obinata, the responsibility of ISP, the role to be played from the public support to reconsider the role of the ISP provider. But in the Provider Liability Act, Limitation Act, it's based on the assumption of the responsibility of the liability of the provider. So from the direct liability to ISP's site blocking obligation, how can we interpret? So let me stop here first. Well, that may be the case, but to begin with, as a higher level, there is a concept of common carriers. Then I think that is being revised by the Provider Liability Limitation Act. Then the same can apply to ISP when it comes to blocking. The same can apply to the ISPs responsible for the blocking. So that's why I referred to the Provider Liability Limitation Act. Sorry, there could have been some gap, if I may. Originally, the Provider Liability Limitation Act, at the bottom of that is contributors' infringement. That is available, of course, in the United States. If you leave it unattended, what is illegal, that cannot be done. So notice and take down. If you notice, then and unless as long as you take it down, then you won't be held liable. So unless you do it, then you're contributing to the infringement. So in order to avoid that, you have to notice and take down if it's a illegal site, for instance. So I think that is where this act is coming from. And you also have a professor.
なんか
Sorry, I am taking up a lot of time. Still Haftang, I have two questions on this. The access providers case, TML, this is before the revision of the law. Therefore, there was no governing law for the claim to be made. That is, I would like to get confirmation from you. And the second question is in relation to overblocking. Users has the right to sue access provider. I think that was explanation. So that is based on Stella Haftung. Even on the basis of Stella Haftung, the users can sue the access providers. That is, I would like to know. What I would like to know.
Yes, thank you very much for these two excellent questions. The first question was on the basis in German law, and indeed there was a change, as I also put into my presentation. First, it was Störerhaftung, which is, as Mr. Tohyama has explained, which is a form of intermediary liability. It also applies to other cases and scenarios, but it applies in particular to intermediary responsibility liability. And then German law changed, and now we can likely find, or we can find, I think that's pretty clear from the case law of the German BGH, we can find the basis for site blocking in Section 7(4) of the German Telemedia Act. That was a change done in 2018. Yeah, that's the first question. And the second question is the right of the internet users to sue. That was something the CJEU requested in the ruling on Article 8.3 of the EU Copyright Directive, that, you know, as a result of the constitutional right of access to information by the internet users, there must be a right to sue. So under both, in Germany of course had to follow this request by the CJEU to provide a right to sue for the internet users against site blocking. And so under both Störerhaftung and also under the new regime, Section 7(4) Telemedia Act, you have the right to sue. German case law says that this right to sue is fulfilled, is given if you have a contractual right to sue. As an internet user, you have a contractual right to sue your ISP, the ISP you're using to get onto the internet. So there's nothing explicit in the law, but the solution is via the contractual claim against your internet access provider.
ありがとうございます。ダンキちゃん。
Thank you very much. Thank you. So it's about time, but maybe we can take one last question. Anyone with the questions from the floor? Well then, thank you very much. So I'd like to close the Q&A session. Mr. Tohyama, Professor Obinata, and Professor Notman, thank you very much. Please send them another big round of applause. So thank you very much. So please give us some time to change the setup of the stage. Thank you very much. And thank you very much for attending the MPA seminar co-organized with the 33rd Tokyo International Film Festival. So I appreciate your support for the smooth proceedings. Now I'd like to invite Mr. Shintaro Ito, the member of the House of Representatives, to give us a closing remark. He's been supporting our industry as the Secretary General of the League of Diet Members for the Promotion of Culture and Arts. Mr. Ito, the floor is yours.
皆さんこんにちは。ご紹介いただきました衆議院の
Well, thank you for the kind introduction. My name is Ito, the House member of the House of Representatives, but Mr. Tohyama has known me well. I've been involved in the filmmaking myself, and I put some small titles on the YouTube, so I'm still a filmmaker myself. Again, last year and this year, I attended this seminar, and the discussion has become even more clear and specific. And during this past year, the situation has changed, I believe. And meanwhile, in Japan, as well as in the rest of the world, many different environments, different situations around the internet has changed dramatically. And Japan is now trying to set up the agency, the digital agency. The purpose is not to establish the agency per se, but how to develop the information system, including digital, for the enhancement of the benefits of the people and for the development of the industries. That's the purpose. And against such backdrop, we had a discussion on site blocking today. But as you heard, when it comes to the site blocking, in different countries, in Japan, vis-a-vis the Constitution, there has been some divided opinions, but also the Telecommunication Business Act and the Copyright Act and the jurisdiction of the court, and all are intertwined when it comes to the site blocking discussion. What was impressive in today's discussion was that about Germany, that the legal contents, up to 4% of the legal contents could be targeted to the site blocking. So if we are to implement the site blocking, then within that particular site, of course there is illegal contents, but there could also be illegal contents. And it's very easy to change the contents as well. So by implementing site blocking, and maybe there's more legal blocking, then how can we lift the site blocking? That's one issue. And also, now that we're in a global age, if the server may not be in Japan, the server may not be located in Japan, then the Japanese TBA is based on the origin of sending. So in the case of site blocking, what can we do? The jurisdiction of the court is also another issue. And this world is making a faster progress. So what we seem to be able to do now may not be available in the future quickly, or what we cannot do now may be possible in near future very easily. And discussion about secrecy, the personal information, it is related to the personal information as well. As we're trying to establish the digital agency, of course, this silo of the different agencies is an issue, but cross-horizontal is another issue, that different ministries are using different systems at the national level as well as the local level. And among the local municipality level, they use different IT systems, and there is some issue with the vendors as well. Of course, we're suffering from COVID-19, but COVID-related information system alone, Ministry of Health and Labor and Welfare has 6 different information systems, and they're not necessarily reconciled with each other, causing some trouble for the distribution. Today's site blocking discussion is of course related to the information system in other fields as well. When it comes to secrecy, the concept of what can be defined as secrecy may vary from one country to another. It may even vary within Japan. So how can we interpret that? And it's now we are guided automatically to something, so people may not know. But then technology may enable that to be known and that to be stored. And what's happening in the rest of the world, for instance, in Europe, other than the former Eastern Europe, site blocking has been adopted widely. But in the United States, site blocking is not introduced yet. Why is that? There is also a political factor here, but 10 years ago, what I understand is that it was proposed to the parliament, but it was rejected. And the big reason is where the GAFA are located. There was a strong opposition opposing lobbying to the government as well as the users. So the situation is different in Japan, but the GAFA still has a very dominant power, and their stance is changing as well. So when we have a discussion on site blocking, how do we view the relationship with the stakeholders in different countries? How is it related to the legal system that exists in different countries? And more than anything, At the end of the day, for all the people, maybe not necessarily 100%, but if 70% can be satisfied, what would be the possible solution to satisfy 70%? I hope that this discussion will make a progress on a global level so that content producers around the world and the users around the world can enjoy the benefit in a win-win relationship. And more than anything, those creators who come up with something beautiful can continue to do so, and that can be enjoyed by us. I hope that we can come up with a solution like that. With that, I am grateful for all of you who are involved in this discussion. I'm not sure if I was able to close the seminar, but this concludes my remarks. Thank you. Thank you very much, Mr. Ito. So once again, thank you very much for attending the MPA seminar co-organized by the 33rd Tokyo International Film Festival. And I'd like to take this opportunity to thank the Tokyo International Film Festival and U.S. Embassy who is supporting us, as well as the Federation of Japanese Film Industries who supported us as well. So those physically here, those attending through the web, thank you very much for your participation. Now, as for the receivers for the simultaneous interpretation, we are collecting them at the exit, so please bring them at the exit. Thank you for your support. Once again, thank you very much.